Good morning, everybody, and welcome to the First District Court of Appeals. We have one case to be argued this morning, and it's City of Cincinnati ex-rel Mark Miller versus City of Cincinnati et al. I understand that the appellees are splitting time. Is that correct? Mr. Tidd, you have 10 minutes, and Mr. Burley, am I pronouncing that correctly?
Yes.
You have 5?
Thank you.
Okay. Thank you. I will be keeping time. Green means go, yellow means you have about a minute left, and red means that your time has expired. Mr. Hartman, would you like to reserve any time?
I will reserve 4 minutes, Your Honor.
Okay. Whenever you are ready, you may come on up.
Thank you. May it please the court, Kurt Hartman on behalf of the relator appellant. First, I appreciate the court's indulgence earlier this week in terms of scheduling as well as opposing counsel on that, so I thank you for the courtesy. This is a relatively simple and straightforward case. It's in a sense a constitutional case. Because if we appreciate the foundation of our constitutional government, be it at the federal, state, or even the local level in the form of a city charter, that sovereign power derives from the people, and that the people, through those instruments, give their government certain powers, certain limited powers, and in so doing, they decree what is the scope and limitation upon the institution. And in this case, the Cincinnati City Council is given solely legislative power per the express terms of the Cincinnati City Charter. As we note in our brief, other charters throughout the state of Ohio sometimes give their city council greater power. Some charters give legislative and all municipal power. But we do not have that in the city of Cincinnati. And if you think about the history of Cincinnati and the charter's reforms of 1920, that makes sense. It was essentially to limit the corruption that was occurring at city council. And unfortunately, in recent past, we've seen when people get outside their lanes, when council members get outside their lanes and go beyond legislative power, what happens? Corruption revisited.
Counsel, this is a taxpayer lawsuit, correct?
That is correct.
And if we look at the language of the taxpayer lawsuit statute, it calls our attention to correcting abuses of government power. I want to ask you about that word abuse.
Okay.
Does that simply mean stepping outside an agency's lane as you've described it, or does it mean something more?
I think it does. I think it essentially means assuming a power that they do not have. I think if you look at the Supreme Court's case in Elra Gas versus and Water Company versus Elra, which involved the sale of bonds to build a waterworks, there in the concluding paragraph, the Ohio Supreme Court says the proceedings of the council for the issuance and sale of its bonds as a means of raising a fund being unauthorized by reason of the failure of council to act within its powers, et cetera, et cetera.
All right, so the concept of abuse that's embodied in the taxpayer lawsuit statute is really something akin to the ultra vires concept.
I think that's a fair characterization, yes, that the council, either council acts legislatively or it does not. And if it acts non-legislatively, under the Cincinnati City Charter, council was not granted that power.
All right, and if we accept all of that, then let's get to the question of characterization of the notwithstanding ordinance. So is this a legislative act or is this an administrative act?
That is ultimately the question, because the city and the parties, the appellees, do not dispute that council is limited to the legislative power. They do not dispute that with respect to zoning, that the enactment of a zoning on this property, particular property, did not change. It was zoned urban mix before, it was zoned urban mix after. They do not dispute that the criteria within the urban mix district did not change. What essentially we have is city council saying, notwithstanding the existing law, both before and after the notwithstanding order, notwithstanding that, we're not going to have the city enforce certain provisions, the setbacks and the density requirements. Those things never changed in the zoning code throughout this. Even to this day, the provisions of the zoning code have not changed. And so what you got is when the city council says, do not enforce it, what is that? And I would point this court to the Ohio Supreme Court's case we cited in our reply brief, the Sensible Norwood case, where essentially through a proposed ordinance or initiated ordinance, citizens were looking not only to reform the marijuana laws in the city of Norwood, but they also put in there how it would be enforced, what provisions of existing law would and would not be enforced. And the Ohio Supreme Court said, that's not a legislative function. How you enforce existing law is not is an executive or administrative function. It's not legislative, and therefore it was not subject to referendum, because the referendum power only goes to legislative acts. And so I think actually sensible Norwood compels the answer in this case. When city council doesn't change the law, they don't amend the zoning ordinance, they don't amend the zoning map, those are legislative acts. Case law is clear. They didn't do any of that. All they simply said is, notwithstanding the current law applicable to this property and all properties within the urban mixed district, notwithstanding that, we're not going to enforce these provisions. That's not enacting a law per sensible Norwood. That is essentially saying how the law would be or would not be enforced. And the Supreme Court in sensible Norwood clearly established that's not a legislative act.
So this is sort of, and I don't want to put words in your mouth, I just want to make sure I understand what you're arguing. But it sounds like you're describing something sort of like a get-out-of-jail-free card that is given to a particular person, a free pass.
Yeah, I probably would not use that characterization, but it basically is saying to as part of our executive function, which they don't have, how's this law going to be enforced? You know, in sensible Norwood, it was saying our police officers will do X, our police officers will not do Y, with respect to existing law. That's what that proposed ordinance indicated. And the court said, you don't have, that's not legislative, therefore you cannot put it subject to referendum. Well, if it's not legislative, then the question is, does Cincinnati City Council have that power? And because of the city charter provision that gives it only the legislative power, it's beyond that. It is administrative. Like I said, I think we all agree, changing the zoning ordinance, correction, adopting a zoning ordinance, amending the zoning ordinance through amendment, all which would then be subject to referendum because those are legislative acts, or changing the zoning map itself, or changing the criteria for the urban mixed district or any district. That's amending it. That is changing the law.
So let me give you a hypothetical. Let's pick a different property, and let's say that the city council adopts an ordinance that says this particular property now has to follow, is in this other zoning district, and now has to follow a different setback. Legislative?
If I understand the premise of your question, they actually changed the zoning classification from urban mix to
Sure,
whatever,
commercial or something.
an existing district.
Yes.
That is a zone change. That changes the zoning map.
What if they don't change the underlying zone, but instead they say this particular property now has a 60-foot setback instead of a 30-foot setback because of some unique attribute to it?
Right. They do not change the zoning on the property. They do not change the criteria for that zoning district. That's not changed. That is not a legislative act then. Because the case law is clear, to be constituted a legislative act in the zoning context, it is changing the zoning code, changing the zoning map, which is part of changing the zoning code, or changing the criteria for that district. In your scenario, though, you're now kind of raising the prospect of possibly spot zoning, which more is changing the zoning of one parcel, contrary to the whole character of the rest of the neighboring property. That, I don't think, was your scenario there. But simply to say, I think if you're in your scenario, if I understood you correctly, was we're not going to enforce the existing law. And we're going to say, yeah, the law remains. On this property, and I think in your scenario, the law on that property stayed the same before or after. It was still urban mix. The urban mix criteria did not change. Every other property subject to urban mix is subject to that. And under the law, i.e. the zoning code, this property is still subject to the urban mix criteria. All in this case, what is happening is council is interjecting itself and saying, our officials are not going to enforce the law. And that becomes administrative executive per sensible Norwood.
Can you switch gears and address the standing question? I know from your briefing, it's your position that a public harm is not required.
Well, I don't think it's required. I think there definitely is a public harm in this case. Let me put that point. You know, the public harm, public benefit, if you really look at it, we kind of call it out in one of our footnotes, ultimately goes to a question of an award of attorney fees under 733.61. I would argue, well, if you've got to show public harm on attorney fees, you don't get to the attorney fee question until you win on the merits. And so you're kind of putting the cart before the horse. But in terms of the statutory provisions, you look at the statute 733.59 and .56, as well as the case law. I'm looking at like the Parks decision from the Supreme Court. I'm looking at the Butler decision and that Elra gas decision. You know, basically the statute says, you know, upon demand, any taxpayer can make a demand to the city solicitor, and upon the refusal, the taxpayer may bring the action for and on behalf of the city, the municipality, in this case, City of Cincinnati. And that taxpayer then stands in the shoes of the solicitor representing the city. You know, the question kind of posited, I look at the Butler decision that we cited page 10 of our reply brief. You know, it says there, and I'm quoting from the decision, it is urged that the plaintiff is not a proper party to make such a complaint, it appearing that he does not suffer any injury by reason of the wrongful practices and therefore cannot maintain the action. The Ohio Supreme Court says we think that contention is unsound. If upon request of the taxpayer, the solicitor refuses to bring the action, the taxpayer may do so by virtue of the statutory provision. He then represents the public just as would the solicitor. This court's decision in the Smitherman case, which challenged the ability of the mayor to appoint to the housing board without the advice and consent of council, contrary to state law. This court simply said the statute is clear, and it's a, you know, you go to the Parks decision that we cite on that page, it's a remedial statute that is to be liberally construed in favor and to advance the purposes that it is designed. And that is really to hold government accountable, to hold government to its powers, and basically recognize ultimately the people are the sovereign, and that the government only has those powers granted to it by the people through their constitution, in this case, the city charter. So if the court doesn't have any further questions, I'll look for my rebuttal.
Okay, thank you.
Thank you, Your Honor.
I will put on the yellow light when it's about 9 minutes in.
Thank you, Your Honor. May it please the court. Kevin Tidd on behalf of the City of Cincinnati. The City of Cincinnati sets the policy for what can be built in the city via the charter. It does this through the zoning code, which is the city's development code. It was created by the council, and it establishes development regulations for properties, such as minimum side yard, rear yard, and front yard setbacks. This also includes landscaping requirements and parking requirements, just to name a few. The council creates these policy regulations, and council can modify this policy by creating new laws, so long as they are in the public interest. The council, through the charter, delegates certain administrative authority to city administrative officials and boards to grant limited exceptions to the zoning code. These are based on pre-existing standards created by the council found in the zoning code. This case is not a situation where an administrative board is granting an exception. This case is a situation where the council is modifying the zoning policy for a property.
So, counsel, I think there's a fine line here, and I'd like you to help me draw it. What is the difference between saying we are not going to enforce a particular law towards a particular person or entity, and then saying we're changing the law for this particular person or entity?
So, Your Honor, those are not my words. Those are Mr. Hartman's words. And he mischaracterizes the way notwithstanding ordinances work. The zoning district doesn't change when a notwithstanding ordinance is passed, but the zoning for the property does change. A zoning notwithstanding ordinance customizes the zoning laws for a given property through that public legislation property. It's no different than placing an overlay district over a property. So we have many overlays in our zoning code. We have urban design overlay districts. We have hillside districts. We have hillside districts. If you look on the zoning map, you're still going to see whatever that base district is. So it could be for example, it could be CCA, which is a commercial district. So if a zoning notwithstanding ordinance is passed for that CCA property, you're not going to see a change on the zoning map itself, no different than if it's in a hillside district or if it's in an urban design overlay district. So if you look at, for example, the College Hill Business District, you're going to see that's actually within a historic district. But you're not going to see that when you look at the base zoning. The base zoning doesn't change. So what I kept hearing Mr. Hartman say was urban mix. So Dunlap, the Dunlap property, for example, that is here, where a low-income development was attempting to build, it is in an urban mix in the Over-the-Rhine Historic District. But when you go on that map, you don't see the Over-the-Rhine Historic District. You're going to see the urban mix. But the zoning did change. It's in a historic district. Notwithstanding ordinances are no different.
So let me pause, because the Donnelly test asks us to look at whether a law is being enacted or whether a law is being administered. And it goes no further. So it doesn't tell us what it means to enact versus what it means to administer. And perhaps it's the city's position, I don't want to put words in your mouth, that this has something to do with who is taking the action. I know in your briefing you were describing a lot about the process that is undertaken, that at the administrative level there's contested hearings and constrained criteria and timelines and other things, and that the legislative process is less constrained, more open to the public, et cetera. Is that what defines enacting versus administering, or is there something else we should be looking to for this difference?
So, Your Honor, I think you hit the nail on the head. That is what we should look at. The correct test to apply when distinguishing between the legislative and administrative actions is the Donnelly test that you cited. Mr. Hartman continues to ignore the Donnelly test, and he does that because it doesn't help him. When you look at the Donnelly test, it's simple. It's whether the action taken was one, creating a law, like a notwithstanding ordinance, or executing or administering an existing law. And to get to your question more in depth, I used to be the zoning hearing examiner. And when I was the zoning hearing examiner, I had a preset, there was a standard that I had to follow to grant a conditional use, to grant a variance. I couldn't just, this seems like a good idea, so I'm going to approve it. I had to look at that variance standard that was created by the council and is found in the zoning code, and I had to apply the facts of that case, of that application, to the standard, much like courts do every single day. Zoning notwithstanding ordinances are different because they're creating a new law. It's the legislative process. And what they're doing is they're setting aside the law and not using that pre-existing standard. There is nothing
What is
in
the
this.
new law that's being created?
So they're customizing the zoning for that property. So in this case, Mr. Hartman, this case is about challenging a low-income development. So under the zoning code at the time, it did not meet the density requirement, and it sought a variance from it. It did not receive it. The city council determined that, hey, this project is in the public interest. Because it's in the public interest, they can set aside the zoning policy for that particular property. And that's what they did. So they changed the law for the property. They didn't look at a pre-existing standard, like the variance standard, and say, this appears to qualify under the variance standard. What they did was they changed the law for the property. They changed the zoning policy, the policy itself. And again, it doesn't matter that on the map, the zoning district didn't change. It's no different than any other scenario where there's an overlay.
So this is not like a legislative veto. This is not a situation where city council is saying, the Historic Conservation Board was wrong. They should have granted the variance. We're going to veto what happened in the administrative process and basically take back the administrative process for ourselves. Instead, what I hear you saying is that the city council was adopting some kind of new zoning requirements, some new property-based requirements for this property.
That's exactly it, Your Honor. They were customizing the zoning for this property because they thought it was in the public interest. And the way the law works, there's a lot of discretion in how the council sets its zoning policy for not just particular properties, but the entire city.
Can you address the standing question?
I can. I did not focus too much on the standing issue. I really think this is I look at it as such a black and white issue on the merits that I'm more focused on that. But I will tell you that I don't think there is standing here. And I think if you look at a case that was actually issued by this court, it's the Phillips Supply case. It repeatedly held that neighborhood-based zoning disputes are not a proper basis for a taxpayer action, because to have standing in a taxpayer action, the objective must be the enforcement of a public right that benefits the public at large. And I don't think that's what this is here. I don't want to go too into what happened at the HCB and Mr. Hartman, but this is clearly, a property owner who doesn't want a LIHTC, low-income housing project, near their property. This doesn't address the public at large. This is about a neighboring property owner.
So motives matter?
I think it matters. Well, it sometimes, but not necessarily. I think still when you look at it, it has to be overarching. Like here, this is just a neighborhood zoning dispute where a neighboring property owner doesn't want to see a neighboring property owner get zoning relief so they can use their property in the way they want to use their property.
So what would be the alternative for that neighboring property owner?
So I think there are a couple options here. First, it's there. These ordinances go through 3 public hearings. So you have Planning Commission, and then you have the Council Committee, and then you have Council. So they can voice their displeasure at all of these public meetings, but they can also be challenged like any other law via a lawsuit, like you see today. If your honors don't have any other questions, I really would like to address the Norwood case that Mr. Hartman cited, because I don't think it has any application in this case. So in Sensible Norwood, a political action committee sought to have an ordinance on the ballot that would decriminalize marijuana in Norwood. The Supreme Court of Ohio held that the ordinance was administrative rather than legislative because a significant portion of it attempted to govern existing federal and state law rather than create a new law. The court explained that the ordinance reached far beyond the enforcement of the ordinance and attempted to prohibit the enforcement, again, of existing state and federal controlled substance laws. Unlike the ordinance in Sensible Norwood, zoning notwithstanding ordinances do not seek to restrict or prohibit the enforcement of existing state or federal law. Instead, it creates a new city law by setting aside city law for a property. So I think it clearly has no application in this case.
Are there other examples where a city council has passed something to carve out a singular property and create a zoning that's for that particular property that differs from the surrounding properties?
Your Honor, it's actually pretty common. I know it's raised in the briefing that this isn't common. But in fact, most zoning legislations, whether it's a planned development, whether it's a zoning-related notwithstanding ordinance, whether it's just a rezoning itself, only affects a single property or site. So if you look at the Phillips Supply case, like that alone is a great example. But look at any planned development that you can think of. You could drive around OTR right now. You can see there's a large Liberty and Elm project going up. It's a large mixed-use building. That was a planned development. You also have planned developments throughout, and pretty much, I would say half the neighborhoods in the city. But just rezoning itself, it's very common. Zoning notwithstanding ordinances only occur, they're not relatively common. They probably happen 3 or 4 times a year. But notwithstanding ordinances themselves are very common in the city. And it's how you see a lot of the signage on the stadiums or the fireworks. Those are different types of, those obviously don't, the signs would affect zoning, but not necessarily the fireworks.
If you would like to yield your argument, you have about, I'll go ahead and give you 5 minutes. So you went a little bit over, but not too bad.
Thank you, Your Honor.
And I'll give you some extra time as well, Mr. Hartman.
Good morning, Your Honors. My name is J.P. Burley. I'm here on behalf of Over the Rhine Community Housing. And Over the Rhine Community Housing is a local nonprofit dedicated to providing much-needed affordable housing in the constantly changing Over the Rhine neighborhood here in the city of Cincinnati. And specifically in this case, they are attempting to bring 44 units of much-needed permanent supportive housing via the LIHTC tax credits to the property located at 2000 Dunlap. And for close to 2 years now, Over the Rhine Community Housing has been caught in the crosshairs of this frankly misguided taxpayer action. Now, Mr. Tidd did an admirable job of explaining the Donnelly test, and we join the city's argument in full on the distinction between administrative and legislative action. But I really want to address a standing issue here because it is a threshold issue that impacts this court's subject matter jurisdiction. Mr. Miller has scrupulously avoided the most recent and most relevant Ohio Supreme Court case on taxpayer standing, State ex rel Teamsters. And that case clearly sets forth that taxpayer actions are reserved for matters where the goal is vindicating a public right, not merely a private dispute. In that case, specifically held that taxpayers cannot contest official acts merely upon the ground that they are unauthorized and invalid. So the point that was raised earlier, that as long as the city council is acting outside of its authority, then the taxpayer action is valid, that is not correct. The Ohio Supreme Court has specifically rejected that point. There needs to be a public right, something implicating a great public interest. And in this case—
Counsel, I want to press on this a little bit further because we've kind of danced around the legislative process that occurred here. What I understand to be the case about this notwithstanding ordinance, especially from Mr. Tidd's presentation, is that it went through 3 public hearings where the public was able to come. Anyone who disputed the proposed change could have been heard in the process. And this was an open, democratic, standard procedure for passing an ordinance. Are we to read something into that process in terms of whether there was or was not a public right implicated and whether there was or was not public harm that occurred, given that there was an open, public, democratic process that took place before this ordinance was passed?
I agree with your description of the democratic process that took place, and there were public hearings. I think when you're talking about a public harm, as with any action for an injunction, you have to look to irreparable harm. And Mr. Miller, in this instance, has not been able to provide either the trial court or this court with one binding Ohio case saying that he's excused from pleading and proving irreparable harm in this case.
Would there
That's
be
because—
any limits? I mean, what are the contours of this taxpayer action? If someone's aggrieved by an ordinance that's passed through this process, if they just don't like, and by that I don't mean to be pejorative, but if they just don't like some act of government, is that enough?
No, it is not, Your Honor. And the crucial difference between a taxpayer action and just a standard private declaratory judgment action to invalidate an ordinance, which is available to Mr. Miller, he did not pursue that, is that a taxpayer action has the possibility of awarding attorney's fees. So the incentive for a party to bring a case as a taxpayer action is that if they win, they might get their attorney's fees paid for. But the Ohio Supreme Court has specifically instructed courts that that is not a gate to be thrown open for any and all instances where allegedly there has been an unlawful act. If a citizen wants to challenge an ordinance, it can do that at any time in a private declaratory judgment action. But in order to bring—
Is there standing for that in this case?
We don't believe there is, Your Honor. So that we address that in our brief, but even under the private standing requirements, we still don't believe that Mr. Miller specifically is affected in any way by this ordinance or even the proposed development, if you were to read that specifically. He hasn't even pled in his complaint where he lives in zoning-related cases, we're always looking at proximity. So, you know,
I'm a
generally
little
adjacent.
bit confused, because what I understood the issue before us was really centered on the authority of city council. And in your discussion of standing, what I'm hearing is more addressing the actual ordinance itself and a grievance towards the ordinance, which is, I see that as separate and apart from a grievance towards the enactment of the ordinance and the authority.
I would agree with you, Your Honor. I think if you properly read this complaint, really what the plaintiff, well, I should step back. I do not agree with the argument that Mr. Miller has put forward, that this is really just about city council's entire policy of granting notwithstanding ordinances. For one thing, this is the same law firm that was representing the neighbors in opposing this development before the Historic Conservation Board.
Well, does that matter?
It does, Your Honor.
Why?
Because it shows that this is merely a challenge to benefit a few rather than a true public interest that is seeking to be vindicated. And under the State XRL Phillips Supply Company case, this court specifically addressed a very analogous situation. Neighbors looking to challenge a notwithstanding ordinance for an adjacent piece of property merely, basically because they didn't like it. And
But we don't have those neighbors in this lawsuit. We have a different person.
I believe, Your Honor, if you look at the information in the record, you can see this case for what it is. The complaint itself attached the demand letter.
Well, I think
sent-
regardless, I'd like for its standing to be addressed with regard to a grievance filed because asserting that that city council had exceeded its authority.
So, Your Honor, there were two requests. The first was to invalidate over the Rhine Community Housing specific ordinance, and the second request was to enjoin city council from granting notwithstanding ordinances moving forward. We believe there's no standing for either request, but specifically on the general question of whether city council may enact notwithstanding ordinances, there's no alleged irreparable harm here. Every time city council enacts a notwithstanding ordinance, it's specifically making findings about why that ordinance is in the public interest and would benefit City of Cincinnati taxpayers as a whole. In this specific ordinance, that's just one example. You can see why city council determined that this was in the public interest, namely to provide much needed affordable housing in a neighborhood that people are being displaced.
Mr. Burley, your
Yes.
time has expired.
For all these reasons, we would respectfully ask that you affirm the decision below. Thank you.
Thank you. And Mr. Hartman, I will give you equal time.
May it please the court, to address some of the issues raised. First thing, Mr. Kidd talks about and acknowledges this resolution did not change the base zoning district. That is correct. It did not change the map. It's the same before, it's the same after. The zoning code never changed. The zoning map never changed. What he does is
Mr.
essentially.
Hartman, so the setback regulation and the density regulation, those are a part of the law, right?
The existing zoning code, that is correct.
Yes. And if they are then subsequently changed, that means the law is changing, right?
If the zoning code is changed, yes.
And so walk me through that.
Because in this, if the zoning code itself is, by adopting a zoning code, by amending it, by changing the zoning map within the zoning code, those are, and the case law is clear, those are legislative acts. But we don't have that in this case. What we have here is basically saying we're going to not enforce the law. It's an enforcement issue. I would call court, it's in my brief at page 19, both Justice Corrigan from the Ohio Supreme Court says, the granting or denial of a zoning variance is an administrative or judicial decision. In the Shoemaker case from the Ohio Supreme Court, it says the actions of the Ottawa Planning Commission in granting a use variance to say, yeah, the zoning says you can use this, but we're going to give you a variance and allow you to do something different. In granting a use variance did not constitute zoning or rezoning, a legislative function. It was a valid grant of a use variance, an exercise of a administrative or quasi-judicial power. The case law is clear when you give variances, when you say we are not going to enforce the law, the existing law. In this particular case,
What
that
is
is a
the-
variance that is saying,
What's the difference between, and this is such a fine point, and I just want to make sure I understand your position on it. What is the difference between granting a variance and like some kind of free pass, you don't have to comply with the setback and density requirements? That's the variance. And then saying, we no longer have the density and setback requirements for this property, legislative. What's the difference in those two?
they could, in that scenario, I don't think there is a difference. If they change the existing zoning law to change the setback requirements, the density requirements for the urban mixed district, applicable
So it would have to be for all.
It had to be for the urban, or they could say, we're no longer going to zone this parcel urban mix, we're going to change it to residential, whatever. That's a change of zoning. That is amending the zoning code. That is amending the zoning map. Those are legislative acts. Case law is clear. We don't have that in this case. There's nothing, and if you go to the.
Tell me why changing the regulations that attach to a particular zone is not legislative.
Because the law has not changed. It doesn't change the law. The zoning code says the same for urban mixed property before and after this resolution or ordinance, whatever you call it. The urban mixed district had the same criteria, both in terms of setback densities, before this notwithstanding ordinance was passed, after they're passed. What it does is all we got right now is essentially the legislature, the city council is trying to designate something legislative by its own fiat. You know, and in my open paragraph of my reply brief, the Supreme Court has said city council cannot designate an action as legislative simply because it desires the action to be legislative. And so they throw ordinance out there. They said this is part of the legislative process. It went through this hearing, that hearing. That doesn't make it legislative. What you got to look at, and the Donnelly test is there. And if they say we didn't apply, Norwood Sensible applied the Donnelly test. And the court said, essentially, when you're saying we will not enforce the existing law, or how we're going to enforce the existing law, and some we will, some we won't. And that's exactly what happens with these variances. We're not
Wasn't
gonna
the
enforce the existing
Norwood
law.
decision, it was sort of a blended decision, so some components of the proposed ballot measure were treated as administrative and others not?
They recognized some was. Basically, what it was is they were codifying what the city code was going to be in terms of marijuana. That is the legislative act, and I think the Supreme Court's recognized that. But when they started getting into how our officials will or will not enforce the law, existing law, existing state and federal law in that case, they said that's not a legislative act, and therefore it was beyond the scope of the referendum, and the entire thing was not subject to referendum or the initiative. And that's the same thing we have here, is they're saying the law has not changed. Mr. Kidd said the map didn't change. The zoning code did not change. All we're saying is we're not going to enforce these particular criteria against this particular property. That's not a zone change. You know, he talked about, and Justice Zayas, you asked about other situations. One, there's nothing in the record in terms of other notwithstanding ordinances, but even if there were, it's really irrelevant. We're dealing with this case brought in its context, which is how all cases get adjudicated. But he talked about, plan development, et cetera, as an architect. PUD, plan unit development, when that is adopted, is a change in the zoning. Case law clearly establishes adoption of a PUD, of planned development, planned zoning, is a change in zoning because there's provisions in the zoning code talking about PUD. So in that case, they go from urban mix, if you will, to this PUD plan. That is a change of zoning. And the Bay thing, and they've never addressed this both below or
So
here.
on this property, if I wanted to know what zoning it was, and what regulations governed it? How would I know that?
You would go to, you'd go to the city code, the zoning code, and figure out, okay, look at the zoning map, this parcel is in
And I'm
which
talking
zoning
about
this.
after this notwithstanding.
Same
we
thing.
passed.
Nothing changed. The law itself, the zoning code itself never changed. The zoning map never changed. And so you go to the map, it's urban mix. You go to the criteria for urban mix, here's the criteria. That's it. And that's why it was not, if they wanted to change the law, they needed to change either the zoning code or the zoning map. All they were saying is, our officials are not going to enforce the existing law. And that's my point. It never changed. A couple more things and I'll get going. Like I said, Sensible Norwood applied the Donnelly test. And in those things, when you're not enforcing existing law, when you're trying to dictate to your officials, don't enforce the existing law, that is administrative, that is not legislative. Supreme Court said it there. Just give a few more points, if I may.
You only have about 30 seconds
Okay, I'm going to
left.
figure that, Judge Kinsley, you talked about the democratic process. That doesn't make something constitutional. Just because it goes through a democratic process, there may be hearings. Doesn't change the constitutionality or not of something. That's really what we're dealing with, is a constitutional question at the municipal level. And the city charter it limits the city council only to legislative power. The desire for city council to make it something more, something what they do more legislative, does not make it so. I think the case law, and you look at the Parks, Butler.
Mr. Hartman, your time has
An
expired.
Elrell decision, I think that gives a standing. I think that clearly shows abuse of corporate power is within the power of Mr. Miller to bring. We'd ask the court to reverse and remand with instructions.
Okay. Thank you. Your
Thank you,
case
Your
has
Honor.
now been submitted, and we will issue a timely decision.
All rise. The Court of Appeals First District of Ohio is now adjourned.
Thank you.